They're hearing by affidavits and a few other things that we're doing as well. We're going to start with Hillcorp Energy. 25951, entries of appearance, please.
Morning, Mr. Hearing Officer. Adam Rankin on behalf of the applicant, in this case, Hillcorp, with the Santa Fe office of Holland and Hart.
Good morning, Mr. Rankin. I don't believe there's any other parties, right?
Correct.
Go right ahead.
Mr. Hearing Officer, this case was previously presented to the division. We provided testimony and affidavits in support. During the course of the presentation, the division asked questions about the proper spacing. We provided a supplemental exhibit packet that identified the basis for the 320-acre stand-up spacing orientation that's based off a 1950s unit agreement that was approved by the commission and incorporated into the order adopting the unit agreement. And so our position is that the 320-acre spacing is correct. It's based on a commission order that overrides the state designated spacing for that acreage. We ask that the additional exhibits be admitted to the record and the case be taken under advisement.
Admitted without exception, taken under advisement. Thank you, Mr. Rankin. Let's move on to ConocoPhillips. This is case 2 on our docket, 25987. Entries of appearance.
This is ours, Mr. Hearing Officer, but Ray Lee Starnes is going to be presenting that case, and she has a telehealth.
Oh, no problem. We'll come back to it.
Okay.
All right, we'll come back to this one. All right, let's go on to number 3 on the docket, 25993, Spur Energy Partners.
Could you say like the name of the volunteer?
Sure.
Because we don't have the document.
Oh, you don't?
No.
There was none posted or sent out.
Freya, can you send out the docket?
Yes, I did forget to do that. I was working in
No problem.
on that out.
I'm sorry about that. I'll say Staley A.
Yes, good morning, Mr. Examiner. Dana Hardy with Hardy McLean on behalf of Spur Energy Partners, and there are no other parties.
Go right ahead.
Thank you. Spur seeks an order pooling additional uncommitted interest under the terms of Division Order R 23913. Exhibits were timely submitted and include the land testimony and exhibits of Colleen Bradley, who's previously testified as an expert in petroleum land matters before the division. Our notice information shows that we sent notice timely by certified mail on April 7th, 2026, and timely published on April 14th, 2026. So with that, unless there are questions, I would ask that the exhibits be admitted and that the case be taken under advisement.
Your exhibits are admitted without exception. Mr. Fordyce?
Yes, Mr. Hearing Examiner, I have questions for the landman.
Thank you. Would you call your landman?
Yes, Miss Colleen Bradley should be online, I hope. I'm not seeing her on the Teams meeting.
Well, we started early, so she may.
Yep, it's possible. We'll text her.
Okay. We can come back to this case.
Okay.
Will you let me know
When
when
she's
you
on.
have her available and we'll come back to the case?
Yes, I will. Thank you.
All right. So let's move on to case number 4 on the docket. This is 26046 Taprock Operating. The well name. It looks like there's 2 cases together. 26047. The well names are Beer 30.
Yep, Jacob Everhart with Beatty and Wozniak, New Mexico, representing Taprock Operating, in case numbers 26046 and 47.
Good morning, Mr. Everhart.
Good morning.
Good morning, Mr. Examiner. This is Jordan Kessler with EOG Resources, entering an appearance for monitoring purposes only.
Good morning, Ms. Kessler. Hardy McLean? Oh, you don't have your docket, huh? I believe you're representing Powderhorn.
Yes, thank you. Dana Hardy with Hardy McLean for Powderhorn.
Thank you. And monitoring?
We are monitoring these.
Monitoring, thank you. Okay, Mr. Everhart, go ahead.
Okay, in case number 46 and 47, Taprock is requesting approval of 2 standard horizontal spacing units and compulsory pooling. In 46, we're requesting for approval of a 643.04 acre standard HSU comprised of the north half of sections 3 and 4, Township 25 South, Range 25 East, Eddy County, New Mexico, which will be comprised of the Beer 30 FedCom 152H well, which will produce in the Bone Spring Formation. In case number 26047, that is a 640-acre standard HSU comprised of the south half of sections 3 and 4, Township 25 South, Range 23 East, Eddy County, New Mexico, which will be comprised of the Bureau 30 FedCom 154H well that will also produce in the Bone Spring Formation. In both cases, the exhibit pack was filed on May 1st, 2026. It contains Exhibit A, which is a CPAC, Exhibit B, which is the application and the proposed notice of hearing, which was filed on March 18th, 2026. Exhibit C in both cases is the affidavit of Senior Landman Erica Shoemaker. She has previously testified and her qualifications have been accepted by the division. Exhibit C1 through C6 are the standard suite of land exhibits that accompany a case of this type. Exhibit D is the affidavit of VP of Geoscience Matt Jones, who has previously testified before the division and his qualifications have been accepted. Exhibits D1 through D5 are the standard suite of geology exhibits. Exhibit E is a notice affidavit showing the notice letters were mailed on April 8th, 2026, and also proof of publication in the Carlsbad Current Argus, published on April 14th, 2026. And with that, Mr. Examiner, I'd like to request that the exhibits be admitted into the record and the matters be taken under advisement.
Admitted without exception, taken under advisement. Thank you.
Thank you.
Ms. Hardy, let me know when Ms. Bradley's available.
She is online
available.
now, Mr.
Excellent. Ms. Bradley, would you turn on your camera?
Hello.
Good morning. I don't see you yet, but we'll get to you. There we go. No, that's Ms. Shaheen.
I can see her.
You can, huh?
Yes.
There we go. Ms. Bradley, please raise your right hand. Do you swear or affirm under penalty of perjury that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
Please spell your name.
Pauline Bradley, Colleen Bradley.
And I've been informed that you have been previously qualified as an expert before this division.
Yes,
In what field?
petroleum landman.
Thank you. Mr. Fordyce?
Ms. Bradley, if I could direct your attention to Exhibit A3, which is page 15 in the exhibit packet.
Okay.
This exhibit is showing 4 tracks in a 320-acre spacing unit, it looks like. And at the bottom, it gives some lease numbers, apparently. Where the bottom 2 look very similar, but one might be for the northwest, northeast, and one is for the northeast, northeast.
Right. So go ahead.
Well, if we could scroll down to the next page, then we'll start getting closer to the heart of my question. So in this exhibit on this page, it's showing tracks 1, 2, 3, and 4A and 4B. So I'm a little confused about what there's 4 tracks, but we have a 4A and a 4B.
Right. So
I'm not sure what the 4A and the 4B are is my question, I guess.
right. That was more a reference for me. So the 4 would just be 4. And so it shouldn't include the 4A or the 4B. So it should just be 4. And that matches up with the legal. So that was more for me. So that hasn't, I can remove that from, because if you notice, it's just for tract 4.
Okay.
So
If we could take a look at Exhibit A4 on page 25.
Okay.
This was, I think, a letter to the overrides, overriding royalty interest. This exhibit on page 25 is discussing 3 tracts of land, with one of them in section 26 rather than section 30.
Right. So
So
the
you can see my confusion, Ms. Bradley. with the 4 tracks and the 4As and the 4Bs, and then this discusses 3 tracks and things don't seem to be matching up. So I was just wondering if you could help clear that up for me.
Right, so that's correct. So track 3 and 4 on the tract breakout, the ownership breakout, those are all, it's the same state lease. So it's here represented as just track 3, and I didn't split out this track 3 into 2 different quarters. And so it's the same legal. So 3 is 3 and 4, and technically 4B and 4A. But I can understand the confusion here, that it's not split out into 4 tracks. But it is the same number of leases with the same descriptions. And this was more to send out to the owners, the override royalty owners, to show them the actual lease breakout instead of by ownership as to, which is for the, my master plat.
Ms. Bradley, could you then maybe, let's say, could you amend Exhibit A3 then in the exhibit packet to sort of remove the ambiguity and make things a little more straightforward, maybe, I guess?
Yes, I can do that, definitely.
On, yeah, the page 15 and 16 that we were looking at earlier. So that it's not confusing what tracks 4A and 4B are, I guess.
Right, no, I can clean that up.
Very good. I have no further questions, Mr. Hearing Examiner.
Thank you.
All right, Ms. Bradley, how long would it take for you to fix the exhibits?
I can get that done today, within the next hour or 2.
Okay, so that your counsel could file an amended hearing exhibit packet with a cover letter by today?
Yes,
Yes.
that's
Okay.
fine.
Very good. Then we'll leave the record open for you to clean this up and submit it by today. And then we'll take it under advisement at that time.
Thank you.
Okay,
All
thank
right,
you.
thank you. Thank you, Ms. Bradley. Let's go back to the case I called earlier. Ms. Starnes is here now?
Yes, thank you.
Yeah, I called case 25987. This is Little John ConocoPhillips.
Yes.
Go right ahead.
Good morning, Mr. Hearing Examiner. Rayleigh Starnes with the Santa Fe office of Holland and Hart on behalf of ConocoPhillips Company.
Are there any other parties?
Yes,
I'm
good
not sure.
morning. This is Jordan Kessler on behalf of EOG Resources, just monitoring.
Thank you, Ms. Kessler. Go right ahead, Ms. Starnes.
Okay, in this case, ConocoPhillips seeks an order approving a non-standard 942 acre more or less spacing unit and pooling all the uncommitted interest in the Wolfcamp formation underlying all of irregular sections 30 and 31 in Township 26 South, Range 33 East in Lee County, and initially dedicated to the Little John 701, 702, 703, 704, 708, 709, 710, 711, and 712 wells. In support of this application, we've timely filed a hearing packet that includes first a cover letter that explains some of our revised exhibits that are included in the packet and reflects that there are actually no working interest owners being pooled at this time, but record title and override only. We've also included the usual suite of exhibits with our compulsory pooling application checklist, our application, the self-affirmed statements of our landman, Matt Darby, and geologist Rachel Shank. Our geologist has previously testified in front of the division, and her credentials have been accepted as a matter of record, but our landman, Matt Darby, has not previously testified or been recognized. So we have included a copy of his resume in our packet and would ask that the division accept his credentials and recognize him as an expert in petroleum land matters. We've also included self-affirmed statement of notice, which reflects that notice was timely sent on March 6th of 2026, and the affidavit of publication, which reflects that notice was published on March 12th, 2026. So if there are no other questions, we would ask that all of the exhibits be admitted into the record and that this case be taken under advisement.
Admitted without exception. Mr. Fortes, who do you have questions for?
I don't have any questions, Mr. Hearing Examiner, but I do have one request for Ms. Starnes.
Oh, go right ahead.
On the CPAC, there are the well descriptions for the 10 wells.
Mhm.
And in those descriptions, has a well name followed by API number pending. And all 10 of these wells have been assigned API numbers.
Okay,
This is what the exhibits show. If you could just update the CPAC to reflect the API numbers that have been assigned.
absolutely.
Ms.
And that's all.
Starnes, thank you, Mr. Fordyce. Ms. Starnes, can you do that by today?
Yes, I can do that this afternoon.
We'll leave the record open in this case till 5 p.m. so that you can get that in and we'll take it under advisement.
Thank you very much.
All right, thank you. Moving on to case 6. Has everyone received the docket now? Yes, okay, very good. We moving on to case number 6. This is Mewbourne Oil 26056.
Good morning, Jackie McLean on behalf of Mewbourne.
Good morning, Ms. McLean.
Good morning, Mr. Hearing Officer Adam Rankin with the law firm of Holland and Hart, appearing on behalf of MRC Delaware in this case. We're just observing.
Perfect, thank you. Go right ahead, Ms. McLean.
Thank you. In this case, Mewbourne is seeking to pull all uncommitted interest in the Bone Spring Formation underlying a 320 acre more or less standard horizontal spacing unit comprised of the south half, north half of sections 9 and 10, Township 18 South, Range 30 East in Eddy County. And this unit will be dedicated to the Milkshake 910 FedCom number 524H well. Exhibits were timely submitted last week and include the land and geology testimony and corresponding exhibits of Josh Anderson and Charles Crosby, both of whom have previously testified before the division as experts in their respective fields. We also include our notice testimony and copies of the notice letter, which was sent on March 25th, 2026. And we have the affidavit of publication from April 14th, 2026. With that, I ask that the exhibits be admitted for case number 26056 and that the case be taken under advisement.
Admitted without exception. Mr. Fordyce, who do you have questions for?
I don't have any questions for this case either, Mr. Hearing Examiner, but I do have one request for Ms. McLean.
Go right ahead.
I have a pool code correction for you for this case, Ms. McLean.
Okay.
The correct pool code should be Loco Hills, Bone Spring East, 39513.
Okay.
You want to read that back?
Loco Hills, Bone Spring East, code 39513.
That's correct.
Can you update your?
Yes, we will get that in by 5 for sure.
Perfect, thank you.
Thank
So
you.
that would be what, the CPAC?
Just the checklist.
The
And
checklist.
the C102s, I believe. need to be changed.
C102 and the checklist? Thank you. All right, we'll leave the record open till 5 p.m. and then we'll take it under advisement.
Thank you.
Thank you. Let's move on to number 7, BTA Oil Producers 26059.
Yes, Jackie McLean on behalf of BTA Oil Producers. And actually yesterday, Ray Alaza Del Spear contacted us and we have agreed to continue this matter to the June docket so that the parties can have time to negotiate.
Who'd you say the party was?
Ray Alaza Del Spear, and they filed the continuance motion yesterday afternoon.
Are they with us today?
Good morning, Mr. Examiner. This is Scott Morgan for Ray Alazadel Spear. And to answer the question, yes, my clients found out Tuesday afternoon, and we reached out to Ms. Hardy yesterday morning, and we were able to agree on that continuance.
All right, perfect. And I'm sorry, who are you representing, Mr. Morgan?
Ray Alazadel Spear.
Can you spell that?
Absolutely. It's put me on the spot. REALEZADELSPEAR.
What type of entity is that?
They're a Texas mineral owner. They've got a lot of mineral interests in New Mexico. They are not an operator. They just have various mineral interests.
Okay, good. And the reason for the continuance that you filed is for what?
We didn't receive notice of it. There was evidently a typo, we believe, in the actual address. We figured it out yesterday, and so we're comfortable with that June 4 hearing date.
Okay, perfect. So you said you filed, well, Ms. McLean said you filed the continuance until what docket would that be?
The June 4th docket.
All right. Hearing by affidavit docket.
Correct.
June 4 HBA. All right. Thank you, Mr. Morgan, and thank you, Ms. McLean. We're off the record in that case.
Thank you.
Thank you. Let's move on to EOG Resources 26075, number 8 on the docket.
Good morning, everyone. Dina Bennett on behalf of EOG Resources.
Good morning, Ms. Bennett.
And there are no other parties that have entered an appearance in
Go
the
right
case. In this case, EOG seeks a compulsory pooling of a standard horizontal spacing unit in the Purple Sage Wolf Camp gas pool. And it's a standard 1,280 acre horizontal spacing unit that covers section 2 and of Township 26 South, Range 28 East, and section 35, Township 25 South, Range 28 East. And we've included the usual suite of exhibits, including the exhibits of the landman who's previously testified before the division, and her credentials have been accepted as a matter of record. And the geologist has not previously testified before the division, so we've included a copy of her resume. And then we've also included the notice materials that shows that notice was timely mailed and timely published. And so with that, I would ask that the exhibits in case number 26075 be admitted into the record. And if there are any questions, myself or the witnesses are available.
Amended without exception. Mr. Fordyce?
I have questions for the landman.
Okay, would you call your landman?
Yes, thank you. The landman is Isabella Sykes.
Good morning, Ms. Sykes. Would you please raise your right hand? Do you swear or affirm under penalty of perjury that the testimony you're about to give is the truth, the whole truth, nothing but the truth?
I do.
Great. Please spell your name.
Isabella Sikes.
Okay, and I've been informed that you have previously been qualified as an expert for this division. In what field?
Petroleum land management.
Perfect. Mr. Fordyce?
Ms. Sykes, if I could get you to turn your direction to Exhibit A9 on page 66 of the exhibit packet.
Yes.
This is a letter sent to COG Operating LLC, I believe for an overlapping spacing unit, as COG has an existing well in, looks like the east half of section 2. If we could look now to turn to Exhibit A4 on page 34. So COG has a well in tract 3, but they're not shown to have an interest in tract 3. I was just wondering if you could provide some comment or explanation. I would have expected COG to have an interest there.
At some point in time, they assigned out of their interests and kept wellbore interest only.
Oh, very good. That explains that. I have no further questions for this case.
All right, so we can take this case under advisement?
We can take it under advisement.
Fantastic. Thank you, Ms. Sykes. All right, we're off the record in that case. Let's move on to case number 9 on the docket, 26076, 26077, 7879, Mewbourne Oil.
Jackie McLean on behalf of Mewbourne Oil Company.
Thank you.
And there's no other party that has entered appearance in two out of the 4 cases.
I think we have Holland and Hart representing Reed Stevens into it.
Good morning, Mr. Hearings. Examiner Adam Rankin with Holland and Hart representing Reed and Stevens in cases 26078 and 26079. We're just monitoring these cases at this time.
Go right ahead, Ms. McLean.
Thank you. In these cases, Mewbourne is seeking to pull all uncommitted interest in the Bone Spring Formation across sections 4, 5, and 6 in Township 18 South, Range 30 East, Eddy County, New Mexico. And these units will be dedicated to the Cerros Locos FedCom wells. Mewbourne is also seeking approval of an overlapping spacing unit in case number 26076 and 26077. And exhibits were submitted timely last week and include the land and geology testimony and corresponding exhibits of Josh Anderson and Charles Crosby, both of whom have previously testified before the division and have been recognized as experts in their respective fields. We've also included our notice testimony along with copies of the notice letter, which was timely sent to all interested parties on April 2nd, 2026. And we've included an affidavit of publication from April 14th, 2026. And I ask that the exhibits be admitted for case numbers 26076 through 26079, and that the cases be taken under advisement.
Admitted without exception, and all 4 cases are taken under advisement. Thank you. Let's move on to Devon Energy Production 26080.
Good morning, Mr. Hearing Examiner. Good morning, Mr. Technical Examiner. Darren Savage with Aberdeen Shield appearing on behalf of applicant Devon Energy Production Company, LP.
Good morning, Mr. Savage. I don't believe there's any other parties
I don't
here.
think so, no.
Go right ahead.
Case 26080 covers lands in sections 19, 20, and 21, Township 20 South, Range 30 East, Eddy County, New Mexico. The landman, Daniel Brensman, has testified previously before the division, and his credentials have been accepted as an expert in petroleum land matters. The geologist, Tom Pirium, has testified previously before the division as an expert witness in geology, and his credentials have been accepted as a matter of record. In this case, Devon seeks an order pooling all uncommitted interest in the Wolfcamp Formation, underlying a standard 1,917.84 acre, more or less, spacing unit comprised of all sections 19, 20, and 21. The unit will be dedicated to the St. Helens FedCom wells. Orientation of the wells and unit is laid down, and the location of the wells is standard. Devon has applied and received approval for the non-standard spacing unit. Mr. Brunsman's Exhibit A includes the usual landman exhibits, self-affirmed statement, C-102, ownership breakdown, well proposals with AFE and chronology of context, and an overview of notice provided. Mr. Perriam's Exhibit B includes a self-affirmed statement, a self-affirmed geology statement, along with 6 geology exhibits. Exhibit C provides a self-affirmed statement of notice for mailings and publication notice. Notice was timely mailed on April 8th, 2026, and timely published on April 11th, 2026. Mr. Hearing Examiner, at this time, I move that Exhibits A, B, and C and all sub-exhibits be admitted into the record for this case, and the case be taken under advisement. Counsel and witnesses are available for questions.
Admitted without exception. Mr. Fordyce.
I have a question for the landman.
Mr. Savage, would you call your landman?
Yes. Mr. Brunsman, can you make an appearance?
Yes, I can.
Yeah, there we go.
Darren, can you hear me?
Yes, Mr. Brunsman, thank you. Would you raise your right hand? Do you swear or affirm under penalty of perjury that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you. Thank you. Would you spell your name?
Yeah, Daniel, D-A-N-I-E-L, Brunsman, B-R-U-N-S-M-A-N.
Thank you. I've been informed that you've been admitted as an expert before this division.
Yes, I have.
In what field?
Petroleum land matters.
Thank you. Mr. Fordyce.
Mr. Brunswick, I'm looking at Exhibit A2 on page 33 of the exhibit packet. Can you amend this exhibit to indicate on the unit recapitulation and for the record title owners, which parties Devon is seeking to pool?
Yes, we can for clarity. Or do you mean the working interest parties, the record title owners, or all?
Indicate on the exhibit which parties Devon is seeking to pool. Could you amend that exhibit for the exhibit packet?
Yes, no, we'd be happy to.
Is that something you think you could turn around quickly?
Yes, we should be able to get it to you by, several hours from now, but today for sure.
Thank you, Mr. Brunsman. I have no further questions.
Thank you.
Mr. Hearing Examiner, if I could just clarify, Mr. Technical Examiner, what are you wanting to amend on that? I'm not sure if I understand what the amendment would be.
On page 33, I believe there were, if you look at the breakdown by track, there are parties that are being pooled. I don't see any parties being pooled here on this, on page 33. On the unit recapitulation and the list of record title owners.
So if I can direct you to page 34, we have a full list of uncommitted parties, persons to be pulled. So you want to, so if I understand you correctly, you want it highlighted on the unit recapitulation in addition to the full list of uncommitted parties, persons to be pulled?
Correct. They're highlighted on the track breakdowns. If we could just add that to the
Okay.
summary list on page
Yeah,
33.
thank you. I understand, Mr. Technical Examiner. I understand that. Thank you.
So, Mr.
you.
Savage, can you have that in by 5 o'clock today?
Should be able to do that.
If you are able to do it, then we'll take the case under advisement. We'll leave the record open until that time.
Okay,
If not, please let us know.
thank you.
All right, we're off the record in this case. Thank you. Let's move on to Mewborn Oil 26083.
Good morning, Dana Hardy with Hardy McLean on behalf of Mewburn.
Thank you.
Good
Mr.
morning, Mr.
Savage?
Examiner. Olivia Atkins with Abity and Schill on behalf of WPX Energy Permian LLC. WPX is just monitoring the case and has no objections at this time.
Thank you. Would you spell your name, please?
Yes, it's Olivia, Olivia, Atkins, Atkins.
Okay, very good. Thank you, Ms. Atkins. Go right ahead, Ms. Hardy.
Thank you. In this case, Mewburn seeks to pool uncommitted interest in the Wolfcamp Formation underlying a 960-acre standard horizontal spacing unit comprised of the south half of sections 22, 23, and 24, Township 23 South, Range 26 East in Eddy County, and will dedicate the unit to the Iceman 24, 22, FedCom 716 and 718H wells. Our exhibits were timely submitted include the land testimony and exhibits of Josh Anderson and the geology testimony and exhibits of Tyler Hill. Both of our witnesses have testified previously before the division as experts in their respective fields. Our notice information is provided in Exhibit C and shows that we timely sent notice by certified mail on April 2nd, 2026, and timely published on April 11th, 2026. So with that, unless there are questions, I request that the exhibits be admitted and that the case be taken under advisement.
The exhibits are admitted without exception. The case is taken under advisement. Thank you, Ms. Hardy.
Thank you.
Let's move on to COG operating two cases, 26084, 26086.
Jackie McLean for COG,
Thank you.
and no other party has entered an appearance in these cases.
Show. Thank you. Go right ahead.
Thank you. In this case, in these cases, COG seeks an order pooling all uncommitted interests in the Wolfcamp and Bone Spring formations. And the Wolfcamp spacing unit will be comprised of the south half of section 29 and all of section 32, Township 25 South, Range 35 East in Lee County. And in that case, there is a depth severance. So COG is only seeking to pull uncommitted interest from the top of the Wolfcamp formation to the base of the Wolfcamp A interval. And then in case number 26086, COG is seeking to pull all uncommitted interest in the Bone Spring formation underlying a 720-acre more or less non-standard horizontal spacing unit comprised of the southwest quarter and west half southeast quarter of section 29 and the west half and west half east half of section 32, Township 25 South, Range 35 East in Lee County. And both of these spacing units will be dedicated to the Boater Federal Com wells. Exhibits were timely submitted for these cases last week and include the land testimony and geology testimony and exhibits from Caroline Frederick and Tyler Patrick, both of who have previously testified before the division and have been recognized as experts in their respective fields. We've also included our notice testimony and copies of the notice letter, which was timely sent on April 8th and April 15th, 2026. And we've included an affidavit of publication from April 21st, 2026. With that, I ask that the exhibits be admitted for case numbers 26084 and 26086, and that these cases be taken under advisement.
Admitted without exception. 26084 is taken under advisement. Mr. Fordyce, 26086.
Yes, Mr. Hearing Examiner, I have a question for the geologist.
Okay, Tyler Patrick.
Good morning.
Good morning, Mr. Patrick. Would you raise your right hand? Do you swear or affirm under penalty of perjury that the testimony you're about to give is the truth, the whole truth, nothing but the truth?
Yes, I do.
Great. Would you spell your name, please?
Tyler Patrick, Tyler, Patrick, Patrick.
And I've been advised that you've been admitted as an expert before this division?
Yes, sir, under geology.
Perfect. Thank you. Go right ahead, Mr. Fordyce.
Mr. Patrick, I'm looking at exhibit B1 on page 42.
And I can share this really quickly.
That'd be great. Yes, sir.
So, Mr. Patrick, the spacing unit as it's depicted is incorrect. As for this case, the east half of the sections that are within the spacing unit are not included. Asking if you could just, for exhibits B1 through B3, make a correction to those to show the spacing unit correctly.
Yes, sir.
And I'm assuming that's something you could do quickly.
Yes, sir.
Thank you, Mr. Patrick. I have no further questions for this case.
All right. Thank you. Miss McLean?
Yes, just want to confirm exhibits B1 through B3 are what needs to be revised.
Correct.
In case number 26084.
Yeah. It's showing 960 acres like in the 26084, but this case is 720 acres. So just to update the exhibit to show the correct spacing unit, B1 through B3.
We will do that. Thank you.
Before 5 o'clock?
Before 5 o'clock.
Fantastic. We'll leave the record open for case 26086 until 5 o'clock for you to submit an amended exhibit with a cover letter explaining why, and then we'll take the case under advisement. Thank you. All right, we're off the record in that case. Let's move on to case number 17 on the docket, Spur Energy Partners.
Mr. Examiner, Dana Hardy with Hardy McLean on behalf of Spur, and there are no other parties.
Go right ahead.
Thank you. In this case, Spur seeks to pool uncommitted interest in the Yeso Formation underlying a 306.59 acre standard horizontal unit comprised of lots 5 through 12, which is the north half equivalent of Section 4, Township 18 South, Range 27 East in Eddy County. Spur will dedicate the unit to the Kite 4 federal wells. Exhibits were timely submitted and include the land testimony and exhibits of Brian Swanson, who has not previously testified before the division. We did provide his resume and he's available for questions if the division has any. We've also provided the geology testimony and exhibits of Matthew Van Wee, who has previously testified as an expert in geology before the division. Our notice information is included in Exhibit C and shows that notice was timely sent on April 17th, 2026, and our affidavit of publication is timely from April 21st, 2026. So with that, I ask that the exhibits be admitted and that the case be taken under advisement.
Admitted without exception. Mr. Fordyce, your questions?
I don't have any questions for this case, Mr. Hearing Examiner. I have a request for Ms. Hardy. On the CPAC on page 2, the entry for well family actually has a well name entered. If we could just correct that to be the well family name. And I have no further questions for this case.
Can you do that by 5?
Yes, we can do that.
Okay, very good.
Thank you.
We'll leave the record open till 5 p.m. And if we receive your amended exhibit packet with a cover letter explaining what you've done, we'll take the case under advisement.
Thank you.
Thank you. Moving on to case number 18 on the docket. This is Mewburn Oil 26088.
Good morning, Mr. Hearing Examiner Yaritza Pena with Hardy McLean on behalf of Newborn Oil Company.
Morning, Ms. Pena.
Good morning, and I don't think there are any other parties.
I agree.
In this case, Newborn seeks an order pulling additional uncommitted interest under the terms of the Division Order R22905. Exhibits were timely submitted in this case last week and include the land testimony and corresponding exhibits of Brad Dunn, who has previously testified before the division and has been recognized as an expert in petroleum land matters. And we also include our notice testimony along with copies of the notice letter, which was timely sent on April 7th, 2026, and the affidavit of publication from April 14th, 2026. With that, I ask that the exhibits in case number 26088 be admitted into the record and that the case be taken under advisement.
Admitted without exception, taken under advisement.
Thank
Ms.
you.
Mangan. Off the record in that case, let's move on to Matador Production. There are several cases here. 26091, 92, 94, and 95. Entries, please.
Yes, good morning, Mr. Hearing Examiner Rayleigh Starnes with the Santa Fe office of Holland and Hart on behalf of MRC Permian Company.
Thank you, Ms. Starr. I don't believe there's any other parties.
Okay, perfect. In these 4 consolidated cases, Matador seeks an order pooling all of the uncommitted interest in the Barnett and Woodford formations, underlying the west half of irregular section 4 and sections 9 and 16 in Township 24 South, Range 36 East, Lee County, and initially dedicates the units to the Roy Turner Statecom wells. In support of these applications, we've timely filed hearing packets that each include compulsory pooling application checklists, the applications, the self-affirmed statements of the landman David Johns, the self-affirmed statements of the geologist Andrew Parker, both of whom have previously been admitted as experts in their field to testify in front of the division. My self-affirmed statement of notice, which reflects that notice was timely sent on April 17th of 2026, and the affidavits of publication that reflect notice was published on April 17th, 2026. I would like to note that our geologist had a time conflict this morning, but in his place is Blake Herber. He is familiar with these cases and he has previously testified in front of the division as well. So if there are no other questions, we would ask that these exhibits be admitted into the record and the cases be taken under advisement.
Admitted without exception. Mr. Fordyce, your questions?
Yeah, I have questions for the landman, Mr. Hearing Examiner.
Thank you. Will you call your landman?
Yes, David Johns, Mr. Johns.
Mr. Johns, would you raise your right hand? Do you swear or affirm on the penalty of perjury that the testimony you're about to give is the truth, the whole truth, nothing but the truth?
Yes.
Great. You can put your hand down. Thank you. Spell your name, please.
David, D-A-V-I-D, Johns, J-O-H-N-S.
Okay, Mr. Johns, it's very hard to hear you, and I'm afraid the AI transcript won't pick up your voice. Would you say that again louder?
Can you guys hear me better now?
Yes.
David, D-A-V-I-D, Johns, J-O-H-N-S.
And you've been previously qualified as an expert for this division?
Yes, sir.
In what field?
Landman.
Perfect. Go right ahead, Mr. Fordyce.
Mr. Johns, if I could direct your attention to Exhibit C3 on page 20.
Yes, sir.
This exhibit shows MRC pooling some unleased mineral interest in Tract 1 and Tract 2, which are fee tracts, and MRC Permian has 100% working interest in Tract 3, a state tract, correct?
That's correct. We have 100% of the state tract.
So if you could go to the previous page, page 19, for the estate of Dorothy W. Price, deceased, would it be correct to say that that ownership is in tracts 1 and 2, not 2 and 3?
Yes, sir. That's correct. That's the typo.
For Region Oil and Gas Company, would it be correct to say that they have ownership in tracts 1 and 2, not 3 and 3?
Correct.
For DAPCO Inc., would it be correct to say that they have ownership in tracts 1 and 2, not 4 and 3?
That's correct. That's a typo.
Okay. This is exhibit will need to be amended for all 4 of these Roy Turner cases to make that correction. And I have no further questions for Mr. Johns on these
Thank
4
you.
cases.
Thank you, Mr. Fordyce. Mr. Johns, how soon can you amend that exhibit?
Early afternoon.
So, Ms. Starnes, if you can get that in by 5 o'clock today, we'll keep the record open and take the case under advisement. If you can't, please let us know. But please file an amended exhibit packet for each of these cases with a cover letter explaining what the change is.
Absolutely, we could do that.
Thank you. Thank you, Mr. Johns, Ms. Starnes. We're off the record in those cases.
Oh, Mr. Examiner, before you move on to the next cases, which I'm also
Right.
presenting, on the Lil John case for ConocoPhillips earlier,
Which one?
the ConocoPhillips Lil John number 4 on the docket, I believe.
That's number 2.
Number 2.
Want me to recall it?
If you'd like, I did misstate, our geologist has not testified before the division previously. And I did state on the record that she had, so I'm happy to correct that on the record. Or if you just want to leave it, that's fine.
No, I'm fine for you to correct it. That's fine.
Okay.
We didn't have any questions for that.
No, we did not.
witness, So I think we're fine there.
Okay, perfect.
Thank you for correcting it, though.
Absolutely.
Appreciate it. All right, we have some Matador cases here. They're all joined, but I'm going to call them a little bit differently based on the pre-hearing conference we had yesterday. I'm going to call the first ones 26099, 26100. Entries of appearance, please.
Yes, Rayleigh Starnes with the Santa Fe office of Holland and Hart on behalf of MRC Permian Company.
Thank you. I don't believe there's any other parties.
Okay, great.
Go right ahead.
In these 2 of 7 consolidated cases, Matador seeks an order approving standard spacing unit and pooling all of the uncommitted interest in the, I have to check exactly which, if these are Bone Spring, Barnett, or Woodford, but these cases encompass all of them. Let's see, you said 99. Okay, yeah, I believe these are the Bone Spring cases. And initially seeks to dedicate these to the Phelps FedCom wells. We have filed our usual suite of exhibit of hearing. We have filed our usual exhibits in our hearing packet for these applications, which include the self-affirmed statements of our landman, David Johns, self-affirmed statements of our geologist, Andrew Parker, both of whom have previously been admitted as experts in their field to testify in front of the division. My self-affirmed statement of notice, which reflects notice was timely sent on April 17th, 2026. The affidavit of publication that reflects notice was published on April 22nd of 2026. And then once again, Andrew Parker is unavailable this morning, but we do have geologist Blake Herber prepared to testify in his place. So if there are no other questions on these 2 cases, I would ask that these exhibits be admitted into the record and that these cases be taken under advisement.
The exhibits are admitted without exception. Mr. Fordyce.
Yes, I have questions for the landman and the geologist in these 2 cases.
Thank you.
So Mr. Johns and Mr. Herber, unless Mr. Parker is back, but I don't think that he is.
Can we get the geologist on the screen?
Yes, I'm here on a
I
separate
see
screen.
you. Thank you. I see you. Ms. Starnes, you said that both have been previously qualified as experts?
Yes, sir.
Except that this geologist was not the one who submitted the exhibits, but has reviewed them and has his own independent expert opinion about.
Yes, he is familiar with these cases and is prepared to testify.
All right, thank you. Would you, no, so Mr. Johns, I've already sworn you in. Mr. Herber, please raise your right hand. Do you swear or affirm under penalty of perjury that the testimony you're about to give is the truth, the whole truth, nothing but truth?
I do.
All right, thank you. Would you spell your name, please?
BLAKEHERBER.
Okay, and I've been advised that you've been previously qualified as an expert by this division. In what field?
Geology.
Thank you. Okay, Mr. Fordyce, go right ahead.
Mr. Herber, I'm looking at exhibit D3 on page 40, which is a structural cross-section.
Yes, sir.
So in doing my research, I've noticed that this Davison well on the right is in section 20 of 24 South. And the West Jowl well is in section 17 of 25 South. So about 5 miles due south of the Davison well. The West Jowl well is labeled as A in the cross section. But if you scroll up to Exhibit D2, the previous page, it has actually A and A prime reversed, it looks like, in these exhibits. So if we could just get a correction to those exhibits to show where those wells are located correctly.
Yes, sir, we can do that.
I have no further questions for Mr. Herbert.
Okay.
Mr. Johns, I'm looking at Exhibit C3 on page 22.
Perfect. And just to confirm, this is case number 26099.
Correct.
Okay. Yes, sir, I'm there.
So on page 22, it's showing that Matador is seeking to pool two overriding royalty interests, Colburn Oil LP and Flotex Oil Company LLC. I have checked your summary of contacts in Exhibit C5 on page 31. And I've also double checked on the postal delivery port pages 44 and 45. And I've been unable to find any evidence in the exhibits that these two interests were attempted to be contacted or received notice.
The two overriding royalty interest owners.
Correct. Colburn Oil and Flotex Oil.
We did not send them a well proposal as they don't own a working interest. We can certainly reach out and contact them and let them know that we were planning on drilling a well, but we didn't include them in our scope of providing notice.
If there's an interest that's being pooled, they should be due notice. And I cannot see where these two interests were ever contacted or received or sent notice or received notice.
We'll work to provide notice to them and make sure we reach out to them and add them to the summary of contacts.
Okay, I don't have any further questions for this case, Mr. Hearing Examiner. Ms. Starnes, are we going to need to continue these cases to cure notice?
Yes, we'll do that and we can file a motion to continue to the June 4th docket. And it's just for the two cases you called, the 99 and 100.
That's why I called them separately.
Okay, perfect.
I'm not promising any other.
That's
I'm not promising anything else on the others. I'm just letting you know.
But for these specific, okay.
So June 4, today's May 7, that should give you time?
I think so, yes.
So both cases will come back around on June 4?
Yes, sir.
All right. And then what about Exhibit D3? I heard Mr. Fordyce wanting corrections on some exhibits.
Yes, will get those corrected and we'll probably file an amended packet when we perfect notice.
Perfect.
If that works.
Yeah, with the cover letter
Yes, sir.
explaining. Mr. Fordyce, I just want to be very clear. Was it only D3 that the geologist had to correct, or was it something else?
Those three for those two cases, that correction, it needs to be made for the other two Bone Springs cases, 101 and 102, which you have not called yet.
Oh, I was just asking you on these two cases, 99 and 100, which exhibits do you want corrected by the geologist?
D2 and D3. One of the two, they're kind of backwards. One of them needs to be corrected.
I think it was D2 corrected to reflect D3. Yes.
That would work.
No, I'm at.
Yes.
Is that right, Mr. Fordyce?
That is correct.
All right. And then we have a notice issue with one party. Is that correct?
Two parties.
Excuse me, two parties. What are the names of the parties?
Colburn Oil LP and Flotex Oil Company LLC.
All right, perfect. All right. So Ms. Starnes, you understand what to do?
I do.
All right,
Thank you.
perfect. Then we'll see these cases back June 4.
Perfect.
All right, thank you, Mr. Fordyce. I'm now going to call two more cases by themselves, 26101, 26102, also Matador Production.
Perfect. Good morning, Mr. Hearing Examiner. Rayleigh Starnes with the Santa Fe office of Holland and Hart on behalf of MRC Permian Company.
Great, go right ahead.
And these two consolidated cases, Matador seeks an order pulling all of the uncommitted interest in the, which numbers were these? 102?
This is 101 and 102.
Well, perfect. These are. Maybe still our Bone Spring cases. And underlying the east half of irregular section 4, section 9, Township 25, Range 36 East in Lee County, New Mexico, and dedicated to the Phelps FedCom wells. In support of these applications, we have timely filed our hearing packets, including CPAC's applications, self-affirmed statements of our landman David Johns and our geologist Andrew Parker, both of whom have previously been admitted as experts in their field to testify in front of the division. My self-affirmed statement of notice, which reflects notice was timely sent on April 17th, 2026, and the affidavits of publication that reflect notice was published on April 22nd, 2026. If there are no questions, we would ask that these exhibits be admitted into the record and the case is taken under advisement.
Admitted without exception. Mr. Fordyce, these two cases?
If we don't need to rehash the geology exhibit, these two cases have the same correction to be made to Exhibit D2.
Perfect.
And I believe you can make that today.
Yes.
So we'll leave the record open till 5 p.m. for these two cases. With cover letter, amended exhibit, we should be able to take this under advisement.
Okay, just to clarify, these were 102 and 103?
101 and
102,
102.
gosh. Okay, perfect. Thank you.
Now we're going to call, let's call 26103 and 104 by themselves. Entries of appearance?
Rayleigh Starnes with the Santa Fe office of Holland and Hart on behalf of MRC Permian Company.
Thank you. Please go right ahead.
Perfect. In these two consolidated cases, Matador seeks an order approving standard spacing units and pooling all of the uncommitted interests in the Barnett Formation. In underlying the west half of irregular Section 4 and Section 9, Township 25 South, Range 36 East. In support of these applications, we have filed our usual hearing exhibits, CPAC's applications, the self-affirmed statement of our landman David Johns, self-affirmed statement of our geologist Andrew Parker, both of whom have previously been admitted as experts in their field to testify in front of the division. My self-affirmed statement of notice, which reflects notice was timely sent on April 17th, 2026, and the affidavits of publication that reflect notice was published on April 22nd of 2026. There are no questions. I'd ask that these exhibits be admitted into the record and these cases taken under advisement.
Admitted without exception. Mr. Fordyce?
Mr. Hearing Examiner, these two cases, 26103 and 104, have the same notice issue with interest owners Colburn Oil LP and Flotex Oil Company LLC.
So do you want to clarify that with the landman, or do you believe that we don't need to bring him back?
I don't believe we need to bring him back. It's the same discussion that we had for 26099 and 26100.
Okay.
Those cases were continued to cure notice.
Okay. No exhibit issues with this case, just the notice issue?
Just the notice issue, Mr. Hearing Examiner.
Ms. Starnes, if you're in agreement with that, you'll bring this case back on June 4th?
Yes, sir.
Or these cases, okay. All right, let's see, June 4. All right. Okay, and I'm going to call your last case, Ms. Starnes, 26105. Entry of appearance, please.
Yes, Rayleigh Starnes with the Santa Fe office of Holland and Hart on behalf of MRC Permian.
Go right ahead.
In this case, Matador seeks an order pooling all of the uncommitted interest in the Woodford Formation, underlying the east half of irregular Section 4 and Section 9, Township 25 South, Range 36 East, and initially dedicated to the Phelps Bedcom wells. In support of this application, we have filed our normal suite of hearing exhibits, including the compulsory pooling application checklist, the application, the self-affirmed statement of our landman, David Johns, the self-affirmed statement of our geologist, Andrew Parker, both of whom have previously been admitted as experts in their field to testify in front of the division. My self-affirmed statement of notice, which reflects that notice was timely sent on April 17th, 2026, and the affidavit of publication that reflects notice was published on April 22nd of 2026. If there are no questions, we would ask that these exhibits be admitted into the record and this case be taken under advisement.
Admitted without exception and taken under advisement. Thank you.
Thank you.
Let's move on to Flat Creek Resources 26110.
Sharon Shaheen on behalf of Flat Creek Resources, and no other party has entered an appearance in this
Good morning,
matter.
Ms. Shaheen. Go right ahead.
Thank you. In this application, Flat Creek seeks to pool the north half of sections 22 and 23, Township 24 South, Range 26 East in Eddy County, New Mexico. This unit will be dedicated to the Jernigan BS2 FedCom number 1H and number 2H. Flat Creek will seek administrative approval of the non-standard spacing unit. This case seeks to pool a spacing unit that is similar to and would replace the spacing unit proposed by Flat Creek in pending case number 25255, where Flat Creek proposed to pool the entire Bone Spring Formation across a depth severance that exists at 8,062 feet, being 300 feet above the top of the Wolfcamp Formation. The application in case number 25255 was first heard about a year ago on May 8th, 2025. Supplemental evidence was submitted on March 19th, 2026 that the division's request in the case was then on the March 26th, 2026 docket. However, no order has been issued. Flat Creek has a farm out agreement with an imminent deadline for production. Flat Creek is therefore filing the application in 26110 in an effort to obtain an order in sufficient time to satisfy the deadline in the farm out agreement in the event an order approving the application in case number 25255 is not issued shortly. And I should also say that they propose to pool down to the depth severance in this particular case. The usual set of exhibits were timely filed last week. The landman, Mike Gregory, has previously testified before the division. However, the geologist, Marshall Davis, has not. Notice went out for the original case in 2025, and there were no entries of appearance at that time. In an abundance of caution, Flat Creek sent notice of the application that's on the docket today. The certified mailing went out on April 20th, which was 17 days ago. Publication was timely on April 23rd. To date, no interest owner has entered an appearance or informed Flat Creek of any concerns regarding the proposed pooling. With that, I ask that the exhibits be admitted into the record and this case be taken under advisement.
Admitted without exception. Mr. Fordyce?
I have questions for Ms. Shaheen on the CPAC on page 4, Ms. Shaheen.
Yes.
The depth severance entry says no, but there's a lengthy, a lot of discussion in the exhibits about depth severance. So should that entry be yes?
Well, that's a good question. I've always wondered about that. There's no depth severance in the proposed pooling. There is a depth severance in the formation. I'm happy to correct that if I've misunderstood what the question asked for.
Yeah, you touch on it in the pooling this vertical extent section, but I think it would be more accurate with that said to say that there is a depth severance and define the depth severance so that that's clear and it would reflect the vertical extent that Flat Creek is wishing to pool in this application.
I'm happy to do that, and we can do that today.
Additionally, there's a correction that needs to be made in the land exhibits. It's actually the C102s. There's two C102s provided for the 1H and no C102 provided for the 2H.
We will fix that as well today.
And as you mentioned, the notice is not timely. It was 17 days rather than 20 days. So how do you propose to cure notice?
Well, I'm happy to continue this to the next available docket so that we can let the time for certified mailing run.
I have no further questions, Mr. Hearing Examiner.
Thank you. Freya, when is the next docket we can put this on to cure notice?
The June 4th docket?
What about, what if we put it at, I mean, I think all that would require, once the exhibits are fixed, the CPAC, the C102s, et cetera, is for Ms. Shaheen to submit those amended exhibits into evidence, and we can take the case under advisement as long as there's no objection. But is there something in late May?
We could do the May 19th docket.
Okay. Ms. Shaheen, does that work for you?
That would be great. I appreciate it.
Okay, you're welcome. All right, so so Ms. Shaheen, you'll continue this to the May 19 docket to cure notice, fix these other things we just spoke about, and we're off the record in this case.
Thank you.
Thank you. All right, let's move on to case 26121, Mewbourne Oil. It also is joined with 26122. Entries of appearance, please.
Yes, good morning, Mr. Hearing Examiner. Rayleigh Starnes with the Santa Fe office of Holland and Hart on behalf of Mewbourne Oil Company.
You?
Mr. Hearing Officer Adam Rankin, entering appearance, just monitoring Matador, MRC Delaware. And also, we've been contacted by EOG, this is Jordan Kessler, and have been authorized to inform the division that they are just monitoring the case and have no objections.
Thank you.
Okay.
Good morning, Mr. Examiner. David Kermsey of Bradford Sayre on behalf of PBX Operations. We are just making an entry of appearance to monitor.
Thank you. Mr. Kermsey, would you spell your name for the record, please?
Yes, David, D-A-V-I-D, Kermsey, K-I-R-M-S-E.
All right, thank you, sir. Ms. Starnes, go ahead.
Okay. In these two consolidated cases, Mewbourne seeks an order approving a standard spacing unit and pooling all of the uncommitted interest in the Bone Spring Formation underlying the west half of sections 20 and 29 in Township 18 South, Range 33 East in Lee County. And these are going to initially be dedicated to the Undertaker 2029 FedCom wells. In support of these applications, we have timely filed hearing packets that include compulsory pooling application checklists, the applications, the self-affirmed statements of the landman, Brock Dixon, the self-affirmed statements of the geologist, Charles Crosby, both of whom have previously been admitted as experts in their field to testify in front of the division. My self-affirmed statement of notice, which reflects that notice was timely sent on April 17th, 2026, as well as the affidavits of publication that reflect notice was published on April 19th of 2026. If there are no other questions, we ask that these exhibits be admitted into the record and the cases be taken under advisement.
Exhibits are admitted without exception. Mr. Fordyce.
Actually, Mr. Sanchez, Mr. Examiner.
Ah, very good. Would you turn on your camera, please?
Yes, it is on.
I see you now. Okay, Mr. Sanchez, do you want to introduce yourself to the regulated community?
Yes, my name's Patricio Sanchez. I'm a native New Mexican. I've worked in the oil industry for over 30 years, and I'm a licensed professional engineer in the state of New Mexico and a certified petroleum engineer through the Society of Petroleum Engineers, and happy to be back with the OCD 30 years later. Worked for him in Santa Fe 30 years ago in the Environmental Bureau for Roger Anderson.
Thank you, Mr. Patricio. Would you like to question any of the witnesses?
Yes, I have just I think this is just more clarification type stuff that can be fixed. It shouldn't impede the approval of these cases. Firstly, Mr. Examiner, I would like them to refer to C2, page 19 of 37. where the table combines both the Undertaker wells, number 521H and 523H. Could we please have those actually broken out individually in both applications? And the same thing will go forward for the next case also, the 122. I'd like that table broken out just for the specific well. And then also,
Mr. Patricio, hold on one second. So Ms.
Yes.
Starnes, do you understand what Mr. Patricio wants?
I think so. You'd like the ownership commitment exhibit broken out so that there's one copy that just
Yes.
says 521 and one copy that just says 523.
yes, that way it's just,
Okay.
case specific and well specific. Thank you.
Yes, sir.
And then just one other under Exhibit E, page 35 and 36 on the mailing. The same thing. They're kind of consolidated there for both wells. Could we have them separated for the specific cases, please?
Yes, sir. I can do that.
And everything else looks fine to me. I think we can, Mr. Examiner, I would recommend that you can proceed with this one with those corrections if they can get them to you as needed.
Okay, thank you, Mr. Patricio. Ms. Starnes, how long would it take to correct that?
I can get those to you by the end of
Today?
today. Yes.
Okay, very good. So then, as long as you submit those with a cover letter and amended exhibit packet by 5 p.m., we'll be able to take these two cases under advisement.
Thank you very much.
Thank you. Thank you, Mr. Patricio.
Thank you, Mr. Examiner.
All right, now we're going to move on to a different technical examiner. This will be the UIC team. I'm going to call first Trace Delaware. This is 26074.
Mr. Examiner, Dana Hardy with Hardy McLean on behalf of Trace.
Thank you. I don't believe there's any other parties.
There are not.
Go right ahead.
Thank you. In this case, Trace seeks authorization to drill, complete, and operate an acid gas injection well, the Hatch AGI number 1, at its Trace Delaware Heritage Treating Facility, which will be located in Eddy County. The well is a deviated well and will be directionally drilled from a surface hole location in Unit I to a bottom hole location in, from a surface hole in Unit I to a bottom hole in Unit I in Section 31, Township 18 South, Range 31 East. The well will inject treated acid gas into the Siluro-Devonian formations, including the Devonian, Riston, and Fusselman, at depths of approximately 13,341 to 14,226 feet. Trace is requesting a maximum daily injection rate of 12 million standard cubic feet per day, and the well's maximum surface injection pressure will be approximately 4,445 pounds per square inch gauge. Our
Could we
exhibits. Sure.
I'm sorry to interrupt, Mr. Examiner. Could we please take like a 5-minute recess for the next technical examiner, please?
Are you saying that?
For Mr. Harris.
So he's not here now?
He is, but I think he's having some technical
Okay.
issues with his computer, maybe.
What I'll do is let Ms. Hardy finish her presentation. We'll accept the exhibits into evidence, and then we'll take a break so that Mr. Harris can come on. I know he's already reviewed this case.
Much apologies to you, sir, and to the other folks there.
Thank you, Mr. Patricio. Please continue.
Sure, thank you. Our exhibits include the testimony of David White, including his CV and the application and notice of hearing, along with the C-108. Mr. White has previously testified before the division and been recognized as an expert in AGI permitting and operations, petroleum geology, seismic and structural interpretation, and fault slip probability modeling. I expect there will be questions for Mr. White. And he does have one clarification to make on the C-108 when he is answering those questions. Our packet also includes the testimony and resume of David Deloso. Mr. Deloso has not previously testified. He is the co-founder and chief operating officer of Trace Midstream Partners II and its affiliate Trace Delaware Treating Services, LLC. We have provided his resume. He's really testifying as a fact witness on behalf of the company. We have provided our notice, testimony, and exhibits, which show notice was timely sent on April 2nd, 2026, and that we did timely publish on April 11th, 2026. So I would ask that the exhibits be admitted into the record and our witnesses are available for questions.
Perfect, thank you. The exhibits are admitted without exception, and we will take a 5-minute break to let Mr. Harris come on the screen. Thank you. We're back on the record. Mr. Harris, I see you. Mr. Getz, I see you. The exhibits have been admitted into evidence in case 26074, Trace, Delaware. Do you have any questions for the witnesses?
Yes, Anthony Harris here. Yes, I do have some questions.
For which witness?
For Mr. White, I assume he's available.
Thank you.
Yes, Mr. White is here in person, so
Please-
calling him to the witness stand.
Please come up to the witness stand. And would you turn on the microphone by pressing the button on the right? Perfect. Would you state and spell your name for the record?
David White, DAVID WHITE.
Great. Would you raise your right hand, please? Do you swear or affirm under penalty of perjury that the testimony you're about to give is the truth, the whole truth, nothing but the truth?
I do.
Thank you very much. You've previously been admitted as an expert for this division.
That is correct.
Ms. Hardy went through a list of the fields that you've been qualified for. Would you state them on the record?
I've been qualified as an expert in geology, acid gas injection well, permitting and operation and compliance, and other related specialties surrounding acid gas injection well permitting, such as induced seismicity risk assessment and those items that Ms. Hardy had described.
Who are you employed by?
Geolex Incorporated.
What is your position there?
I'm the vice president and senior geologist.
Okay, perfect. Thank you. Mr. Harris?
Yes, good morning. Good morning, Mr. White. In your application that was submitted, it was 135 pages long. Could we please go to page 136? Sorry, page 26 of 135.
I was wondering how Ms. Hardy was going to do that.
Yeah, I was wondering about that math too. Okay, thank you. So in your executive summary, in the second paragraph, it mentions that a proposed Hatch AGI one well is designed to address the anticipated sour gas disposal needs of the Trace Delaware Heritage Treating Facility. Just one question is, what is the I'm assuming that facility has not been constructed yet. Is that correct?
It has not.
Okay. Is there an approved development plan for that through the BLM, or what is the status on that?
We began working with the BLM with respect to this project in late Q4 2025. I think Mr. Deloso, who is here on behalf of the applicant, can provide a little bit more clarity on the status of the facility and the timeline for the facility. But ultimately, it is kind of in the development phase, but working with BLM to move forward with all the approvals necessary for it.
Okay, thank you. Mr. Getz will be joining us later. He may have some follow-up questions on that, but for now, we'll move on. So where will the production come from that will feed this facility? Are the existing production wells? Are there new production wells that will need to be drilled? Or where is the source gas going to be? Where will the source gas come from for this facility?
In terms of the source gases, my assumption would be that it would be from existing and planned development within the area. Again, in terms of the specific assets or fields that are being developed that are part of why this facility is being proposed and constructed. Mr. Deloso from Trace can probably speak more to that.
Okay, thank you. If we could go to page 27, please. And if we look at the fourth paragraph on page 27, it says the proposed maximum allowable operating pressure, MAOP, requested for the Hatch AGI-1 is approximately 4445 PSI. And that's based upon an anticipated bottom hole pressure of 6,287 PSI. So is it safe to assume that 6,287 PSI is will be your abandonment pressure at the end of the life of this well?
No, I think that would be the initial pressure based on current subsurface data that are available to evaluate reservoir conditions. The abandonment pressure or anticipated abandonment pressure will ultimately be a bit of a moving target with respect to how the well is operated. But the existing geologic simulation model that supports this application could be utilized to forecast an initial estimate for the abandonment pressure.
Okay, yeah, that's one thing we would want to have from the operator is a statement on what the anticipated reservoir abandonment pressure will be in the future, and also what the required density of the kill fluids would be to kill the well or to mitigate a well control incident. So is that something that could be provided?
Yes, absolutely.
Okay, thank you. If we could move to page 36, please. Okay, in section 3.4, on to the third paragraph, it mentions how the equilibrium software in the last sentence, the equilibrium 3.1 software, and it employs a modified Peng-Robinson equation of state. So that's the basis for your estimates of the maximum allowable operating pressure of 4445 psi. Is that correct?
Yes, that is a component that goes into that determination, utilized specifically for determining what the acid gas density of this particular mixture would be under surface conditions, bottom hole conditions, and the like.
Okay, thank you. So then on page 37, we could just move down to the next page. So if we look at, we have I guess the third paragraph where it says where specific gravity equals the average specific gravity of the treated acid gas in the tubing, whereby the specific gravity at the top is 0.65 and the specific gravity at the bottom is 0.82, and then it references table 3. Do you see that particular line I'm referencing?
Yes.
Okay, so then the specific gravity of 0.65 and 0.82, you're then taking the average of those two to estimate what your maximum operating pressure will be. Is that correct? The IP
That's
max?
correct.
Yeah,
That's
okay.
correct. Or to incorporate the acid gas density or average acid gas density into the typical calculation for determining that MAOP.
Okay. Thank you. If we could just move to page 38, table 3. So if we look here at the conditions in the second table, the conditions at the wellhead, the pressure is assuming 1,800 psi, and then again the bottom hole pressure in the conditions at the bottom of the well is 6,287. And we've already established that those will be the initial conditions, the initial injection conditions for the well. Is that correct?
That is correct.
Okay. So then over time, I think would you agree that over time the reservoir, the bottom hole pressure and the reservoir pressure will increase over time? Is that a fair statement?
That is correct to some degree, depending on the ultimate attributes of the reservoir and offsetting operations.
Okay. And then so as the reservoir pressure increases, the wellhead pressure will increase. And as those parameters change, the specific gravity, would you agree that that would also increase?
Yes, that's correct.
Okay, so what we're seeing here is, or your maximum allowable operating pressure is based upon initial conditions. It doesn't necessarily reflect what the maximum operating pressure should be in the future. So if we were to issue this permit, it would be valid for initial injection conditions, but if we see pressure increase over time, that maximum allowable operating pressure would ultimately decrease because the specific gravity is increasing. Is that a fair statement?
It is based on these assumptions of surface operating conditions.
Okay, thank you. So since I do agree that the requested maximum allowable operating pressure is valid for initial conditions, but it doesn't consider the change in specific gravity that could potentially occur over the life of the well as the reservoir pressure increases. So that could pose potential issues with containment, which is the primary concern in this case for this particular discussion. So one thing we would request is, or include in the application, in the order, is a condition of approval that number one, you submit an estimate of, well, prior to issuing the order, please submit an estimate of your abandonment pressure, what that abandonment pressure would be. And then we would include a condition of approval in the order to address the potential change in specific gravity that will occur over the life of the well from the perspective of ensuring containment. So we would want to see a calculation for what the maximum operating pressure would be when abandonment conditions are achieved. And that would also incorporate, it would kind of be like just a short technical analysis that would include the step rate test information that you plan to collect on this well, which will identify the parting pressure for the formation. And then also it would address the specific gravity of the fluid at abandonment conditions. And also the study, or the short analysis, could also include the in situ stress data that you'll acquire from, that you've committed to acquire from the dipole sonic logs, which we'll get into here in just a minute. So do you have any concerns with that particular condition?
No, I don't think so. And ultimately, kind of the challenge around those points that we're discussing kind of leads us in kind of our overall assessment of a well and development of an application as, you know, pertinent to all of this and the ability to maintain containment. We further strengthen in our applications with those assessments of fracture gradients utilizing dipole data, but certainly don't have any objection to those additional items.
Okay, thank you very much. If we could move back up to page 32, please. Okay, thank you. If we look at the table 1 for your surface casing, your hole size will be 24 inches and your casing size is 20 inch. I know this may be somewhat of a standard design that you've used in the past. One question is, have you encountered any issues with cement quality based upon that particular hole size and that casing size? Because by some industry standards, that could be considered low clearance, which could pose challenges for mud removal and cement placement. So just like to get your thoughts on whether you've encountered any issues with cement quality using that particular configuration.
And for clarity, you're referencing the surface casing diameters?
Correct. For example, a 24 inch and 20 inch casing will give you, say, a 2 inch clearing, 2 inch annular clearance on both sides of the casing. There's some industry best practices that would recommend a 26 inch hole for a 20 inch casing. Do you have any thoughts on that, or have you encountered any issues with cement quality using this particular configuration? Cement bond quality.
You're correct. We have utilized this configuration multiple times before. With respect to surface casing, have not had any cementing issues or bond quality issues that I have participated in or seen.
Okay. Thank you. If we could move to page 33, please. I guess before we leave that, in your application, you do commit to running cement bond logs for starting at the intermediate casing, I believe. One thing we would want to see is that would want to see a bond log run on the surface casing. Are there any concerns with that?
No, and I believe in my written testimony, expecting that requirement as part of a condition of approval, I think we had attested that we would do so in my written testimony that was submitted after the original C-108.
Okay, thank you. On page 33, we're looking at table 2 here. So the conductor. I guess what is the general purpose of this conductor? Is it basically serving as a seller, or what is the purpose of that casing, that particular string?
Yeah, just a seller and allowing circulation for that.
Okay, so would there be any groundwater penetrated before that conductor is set? Do you anticipate encountering any groundwater prior to setting that conductor casing?
I don't believe any we would probably need to look back to the section covering groundwater to get confirmation of that. My apologies, I'm not intimately familiar without moving to that portion of it at what the groundwater depth would be.
Yeah, no, I appreciate that. Your one table here did mention that the Docket group was anticipated, the formation top is anticipated at 121 feet, which would be just below your conductor here. But one concern from OCD perspective is that if the Docket group contained any water, groundwater, then your conductor casing sort of becomes a potential conduit or contamination for groundwater. So having a ready mix slurry for that particular conductor casing would pose some concerns for OCD. So we would probably want to include a condition that if groundwater is encountered prior to setting the conductor casing, that something other than ready mix be used. We'd want to see probably a conventional cementing operation performed whereby you circulate your cement down the casing and up the annular space. Is there any concerns with that?
No, there's not.
Okay, thank you. Okay, if we could move to page 34, please. So it just mentions here, section 3.2, the geophysical logging, and how you'll have open hole geophysical logging performed underneath the surface casing. But then the second sentence says the proposed open hole logging suite will consist of gamma ray, density, resistivity, neutron porosity, sonic porosity, 360-degree caliper measurements with integrated borehole volume. Additionally, an formation microimager, FMI, and sonic dipole logs will be recorded along the proposed injection interval and the overlying caprock. So basically you will that require running two separate, or I guess separate logging runs for the production casing prior to setting the production casing, and also for the open hole? Because if we look on page, if we look to page 62, yeah, thank you. So your production casing, if we could just scroll down to the bottom, please. Your production casing is basically going to be set at 13,619 feet, which is right at the top of the Devonian. So in order to characterize the Woodford and the stress in the Woodford, you would need to run the dipole sonic across the Woodford prior to setting the production casing. Is that correct?
That is correct, and that is typically the way those are performed in separate logging runs.
Okay, so you'd have basically two runs for your dipole sonic, one across the production prior to setting the production casing, and then also a separate run for dipole sonic to characterize the stress in the injection interval. Is that correct?
That is correct.
Okay, thank you very much. If we could go to page 46, please. So in section 4.8, in the second paragraph, in the last sentence, it says, as shown in figure 15, these compiled fluid records and testing operations indicate increased pore pressure gradients from the lower bone springs to the Woodford Formation strata, expressed in the utilization of heavier drilling fluids. And then normal pressure conditions are observed to return underlying the Woodford Shale. So with these anomalous pressure gradients that are anticipated, I guess, do you anticipate any challenges with drilling that section in terms of fluid loss, or potentially is there any managed pressure drilling planned for that whole section?
So managed pressure drilling will likely be considered as this project area does fall within what literature is available describes as the Eastern Delaware Basin overpressure interval. So it will be considered in the drilling and completion activities for the well. However, with respect to those publications, the overpressure conditions are not necessarily as significant in this area as they are in some other areas of the basin, such as, more eastern towards the platform margin and southeastern New Mexico. So at this point, it's a matter of being prepared for it, recognizing it, and ultimately, as we get closer to drilling activities, making sure we understand whether or not those MPD components are necessary.
Okay, thank you. And I guess along those same lines, would you have any contingencies from a cementing perspective? Would you have any contingencies to run DV tools and external casing packers if necessary to have multi-stage cementing across that interval? If the pressure variance was such that it demanded, a multi-stage job?
Yes, absolutely. We would have those contingencies.
Okay, thank you. And then if we could just go to page 62 again for the wellbore diagram. Okay, thank you. So if we look at your first intermediate casing from about just below 2,000 feet, you've got the Tanzil, the Yates, Seven Rivers, Queen, Grayburg, San Andres. I'm not familiar exactly with this area, but you can also potentially face multiple pressure regimes across that interval as well. Is that fair to say?
You can. The primary motivation for isolating that section or those groups of formations in this casing string is ultimately a significant portion of local production has occurred within those intervals, underlying the salt and overlying the relatively lower pressure intervals of the Delaware Mountain Group. In our experience, variable pressure conditions in this interval haven't been a condition that's not manageable. And so ultimately we've landed on that isolation design via casing those intervals together.
Okay. So then if you did encounter, for example, if the Queen was if there's pressure maintenance occurring in the Queen, and if you have large variability in pressure regimes again, would you have contingencies here from a cementing perspective to run multi-stage cement job if necessary?
Yes.
Okay. Thank you. That's all the questions I have. I can turn it over to Mr. Getz.
Thank you, Mr. Harris. Mr. Getz?
Good morning. My sole question, Mr. Harris has covered most of everything I had. Well, we had one item that we did not cover. The issue of a well and the proximity of the proposed, give me a moment, proposed path for the deviated well. there is a lateral that crosses that path. Actually, there are two laterals, but there's one shallow in the Bone Spring. And I guess this would be for Mr. White. I do not see any reference other than listed in the wells looked at. But we have, let's see, it's the API number 30015-31647. Has two laterals coming off of it. It is the West Shugart 31 Federal Com number 1. The second lateral, which was put off to this well, crosses over the proposed bore path in unit letter O, and at that depth, the well is within the Bone Springs. If you could, as part of your submittal, provide us at least some sort of assurance that it's been taken into consideration and that we will not have issues with these two wells crossing their paths. Understood?
Understood.
And then the last item is for Ms. Hardy. At this point, we have purely an application before the BLM. The issuance of a UIC permit for AGI wells has been for a facility in existence or for a permit that's been approved. What do you foresee is when the BLM is going to release an approved permit?
Mr. Getz, we have Mr. David Deloso here, and he's available to answer questions if you would like on that. It's my understanding that that is imminent, that the BLM will issue the right-of-way permit following submission of the APD, and that the APD is due to be submitted within the next week.
Mr. Getz and Mr. Harris, why don't we call Mr. Deloso, and that way Mr. Harris can get his questions answered more fully, and then you can also follow up Mr. Getz if that works for both of you gentlemen.
That does.
Okay. Thank you, Mr. White. You're excused. Mr. Deloso, would you please come to the would you turn on the microphone? Is the button on the right? There you are. Okay. Would you, good morning, sir. Would you state and spell your name for the record?
Yes, my name is David Deloso. That's DAVIDDELL''OSSO.
Thank you. Would you raise your right hand? You swear or affirm under penalty of perjury that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
All right, thank you. Have you been recognized as an expert before this division in any field?
I have not.
Okay, very good. Are you seeking to be admitted as an expert?
I'm not seeking to be expert.
Okay. Who are you employed by?
I am employed by Trace Midstream, the entities mentioned earlier by Ms. White. Ms. Hardy, excuse me.
Okay, would you just answer the question fully then? Who are you employed by?
Trace Midstream.
Okay. I didn't understand what you were saying about the entities earlier mentioned by Ms. Hardy.
Well, I mentioned that because I'm here on behalf of Trace Delaware Treating Services LLC, which is a subsidiary of my employer.
Ah, I see. Okay, very good. Okay, and all right. So we'll restrict your testimony to lay witness testimony for facts that you know yourself. Okay.
Okay.
All right. Mr. Harris, would you ask those questions that you asked Mr. White that he wasn't able to quite answer earlier?
Yes, I can. So I'll just repeat the question. So since there's no processing facility yet, what is the anticipated source of the gas for this treating facility?
So the source of the gas, which will be treated at the Heritage Amine Treating Facility, will be sourced from kind of easternmost Eddy County and western Lee County. And this is a combination of existing Trace Midstream customers and also prospective customers that we're in commercial negotiations with currently. I'd like to add too that as part of this, this is mature enough. These are subject to confidentiality, but they're mature enough to where I did want to point out that we have ordered several thousand horsepower of NACE compliant compression for sour gas service, and we've also ordered long lead equipment for a NACE compliant compressor station rated for sour service. Additionally, we've ordered about 10 miles of ANSI 600 NACE compliant gas pipeline. And the intent of that is to connect gas to the Heritage amine treating facility and ultimately to a Hatch AGI well.
Okay. So is there an approved development plan or for the wells that will feed this facility? I'm assuming most of the wells already exist. Is that correct?
Most of the wells are to be drilled primarily in some of the shallower horizons and in formations that have not yet been developed and produced at scale by the specific customers that we're talking to.
Okay, thank you. Mr. Getz may have some additional questions.
Mr. Getz?
Yes, okay. Well, you raised one more question for me. Good morning. So we refer to the Heritage facility and we refer to the Hatch well. Are these both on the same properties or are these separated?
These would be on two separate BLM grants, but they are adjacent. They share a common boundary.
Okay, so we're in proximity then. We're not going miles or anything from between well and facility.
That's correct. The Heritage site is directly adjacent to the east of the Hatch site.
Okay, very good. So the discussion on the permit. Okay, so are we, is the BLM issuing separate permits or I don't quite understand the basis of this. And the reason why we ask is because, again, the issuance of an AGI permit is associated with a facility. And at least we have to have some sort of, other than a commitment of resources, but an actual permit since this is both BLM land and BLM minerals. So I'm hearing that we're doing an APD. It is typical that BLM does an APD as a right-of-way when it's not associated with a mineral lease. Are we getting separate permits for the Heritage and the APD, or what is the status?
Yes, the Heritage and Hatch sites will have separate BLM right-of-way grants. And they're part of the reason they're connected and one has not preceded the other is that the BLM preferred, given that they are adjacent, to conduct a single environmental assessment. And so the final step, all steps prior to the submission of the APD have been completed. So that is the last component. So per the testimony, we've been working with them for several months and they are anticipating receiving the APD imminently.
Well, that's fine. What about the actual facility? What's the status of the permit for the amine or the compressor or any other of the equipment?
For clarification, are you referring to the air permit with the NMED or
No. What I'm
right
talking
away?
about is okay. BLM has the right of way. It is for your surface facility. What is the status of that right of way permit?
It currently has a pending number, and the only reason that we haven't already had that facility permitted is because the Common EA will require the APD for the Hatch facility to be submitted. It like the Hatch right of way is imminent upon submitting the APD.
This puts us into a little chicken and egg situation since the issuance of a permit cannot be done. I think we need further discussion outside of this realm. You've created a situation that makes RUIC's rule not applicable to what your situation you've created. And so we should have a discussion. At this point, our issuance for the UIC permit is fixed on the existence of a facility. The APD is really not of our concern other than we do approve it. And the conditions in the UIC permit are applicable to the APD. The issuance of an AGI well is tied to a facility. And I would suggest, since we're going to be asking for additional information, that we have a meeting outside of this and let's get this resolved. Otherwise, if we don't have the permit for the facility, you don't get the AGI well permit for UIC. That's how we do our business. Okay.
Understood.
Other than
I think
that, that's no more questions.
All right, thank you, Mr. Harris, Mr. Getz. Ms. Hardy, how do you want to proceed?
Well, I had a question for Mr. Getz, and would it be possible for Trace to submit the permit information from the BLM for the facility once it's submitted or once it's issued?
Well, we'll have more discussion. At this
Okay.
point, I need a legal document that says I have a facility. And in the past, for the last 20 years, well, now 25 years of doing this, in our agreement with the EPA, we've had this rolling discussion because some people in their applications throw in the word geosequestration. And that has caused us as a division and under our primacy agreement to have to agree with EPA that in these cases, the reason we have the ability to issue UIC Class 2s associated with acid gas injection is because of the fact we can tie it to a facility. And in most cases, it's already been in place, and we've gone even to the point where you've had compression stations that were being turned into amine facilities, and we even went that far as to issue a permit. And right now, all we have is paperwork. So let us have a discussion outside of this. Let's see how we can find a path. But this is kind of a situation that needs to be discussed.
Understood. And then is there a list of supplemental information that you and Mr. Harris would like us to provide? I know Mr. Harris asked Mr. White a number of questions, and I wanted to make sure we had the list of what we need to provide.
Well, I'll let Mr. Harris open up on that. I do believe that I asked about the one well and its ability or crossing of the path of the proposed drilling, that some sort of assessment be done, or at least some sort of statement as to collision potential, or is it going to be there, isn't going to be there. So that I did have that one request for that one well.
Yes, thank you.
Mr. Harris?
Yeah, and just one item from my side is what the anticipated abandonment pressure would be. And based upon that abandonment pressure, what the required fill fluid density for the well bore or for the well would be.
Thank you.
Thank you.
Okay, so Ms. Hardy, it's my understanding based on the discussion that we just had that there are documents that need to be resubmitted, but that there's also a conversation between the division and your client that you're going to facilitate before the case comes back. Is that your understanding?
That is my understanding.
Okay, so after, so when you know how you want to proceed with this case, will you let the hearing bureau know, file a motion to continue, but add some information in the typical motion that tells me what happened with your conversation with Mr. Getz and Mr. Harris, and that you have submitted an amended hearing packet with a cover letter, so I know how to proceed.
I will do that. Thank you.
All right, perfect. We're off the record in this case. Let's move on to another case. 25801 Milestone Environmental.
Thank you. Dana Hardy with Hardy McLean on behalf of Milestone.
Thank you.
Morning, Mr. Hearing Examiner. Adam Rankin with the Santa Fe Office of Holland and Hart, appearing on behalf of COG Operating LLC.
Okay,
They're
I had a
mon-
different.
Yeah.
Oh.
Miss Hadley is not available today, so we're covering for her. No objections to the case. COG is just monitoring at this time.
Sounds good.
Yeah.
Ms. Hardy, go ahead.
Thank you. In this case, Milestone seeks an order authorizing it to increase the rate of injection through its BESA SWD number 1 from 10,000 to 20,000 barrels a day. Order number R21441 had approved a maximum injection rate of 10,000 barrels per day and authorizes the director of the division to increase the rate upon a showing by the operator of information indicating that the injection rate will not result in a pressure that exceeds the formation parting pressure, nor result in migration of the disposed fluid from the injection interval. Here we have provided testimony by Mr. Adam Haker and Mr. Jason Larcher. We've provided their CVs. Neither of them have previously testified as experts. And they established in their testimony that the conditions referenced in order R21441 will be met here such that the injection pressure for this well can be increased. We provided our notice testimony, which shows that notice was timely sent on December 9th, 2025, and that notice was timely published on December 16th, 2025. So I expect there may be questions, but I would ask that the exhibits be admitted and accepted into the record.
Without exception, Mr. Getz?
Yes, sir. Okay, good morning again, Ms. Hardy. At this point, truly, we don't have anything with regards to the submittal of the affidavits. We do have issues with compliance with the existing order, R-21441. And we can use your exhibit as a reference point. So, let's start with page 16 of 47.
Just pulling that up.
Ordering paragraph 11.
Sorry, Mr. Getz, what was the page number?
Was 16 of 47.
Okay. Okay.
Page 6 of 9, ordering paragraph 11. Supposed to provide a static hole measurement. There's no record of that being provided. The ordering paragraph also sections back to ordering paragraph 20, which is the commencement of injection notice. There's no record of that. Please resolve that if you would.
We will do that.
Second item is ordering paragraph 15, which is on page 17 of 47.
Yes.
Wait, okay. So I'm looking at ordering paragraph 15. We were supposed to have analyticals of the slurry fluid at least 4 times a year, quarterly monitoring. Since it commenced injection in December 23, 2022, at least my best estimate, there should be 16 reports easily. I do not see a single one. Could you see if the operator can resolve this deficiency?
Yes.
Okay. And then the only other item I have is an inquiry to Milestone. Was any attempt made to reach out to the New Mexico State Land Office or discussion of this application?
We did provide notice to the state land office and did not hear from them on this application.
Very good. My advice is that it's not critical, that I do not see the need for a continuance, but if you would provide this information, I would recommend to the examiner that the case be taken under advisement.
Thank you, Mr. Getz.
Thank you. We will provide that information.
So, Ms. Hardy, when can you provide that?
I would need to consult with my witnesses, and I believe they are on the Teams meeting.
Go right ahead.
If Mr. Haker or Mr. Larcher could please turn on your videos.
This is Mr. Larcher. We have, I will have to look for some of those records. The well was drilled a few years ago, and I'll need to reach out with our consultant to find those records. So I don't have an exact date.
But it won't be, but Mr. Larcher, that means it won't be today. Is that what you're saying?
I don't think it will be today. I will reach out to them and see what we can do.
Okay. Well, we're not trying to pressure you, Mr. Larcher. I'm just trying to figure out how to proceed with this case. So,
if we have those, well, I'm sure we have them. Let me find where that we will get them to you. I think a week is sufficient for that.
Okay, perfect. Thank you, Mr. Larcher. Ms. Hardy, do you have any other questions for these gentlemen before we talk?
Only to make sure that you all understand what is being requested and that we can track that down and provide it.
And that was, just to confirm, that was items on the original order.
Yes.
Item 11,
15, and 20.
Okay.
Okay.
Are you finished with these gentlemen?
I think so. Yes. Thank you.
Just want to make sure. All right. So, Ms. Hardy, why don't you continue this case to the 19th? And we can conclude it at that.
Sure, I will do that.
Okay. And before the 19th, would you file a amended exhibit with a cover letter?
Yes, I will.
All right, perfect. Thank you. All right. So this case is not taken under advisement at this time, Mr. Getz, but I have a feeling it will be on the 19th of May. All right. Now we are at our last case of.
Mr. Hearing Examiner, if I
Ms. Starnes.
interrupt you very
Go
briefly,
ahead.
I have a quick update on the notice issue for the Phelps cases.
I don't know which case.
They were 23, 24, 27, and 28 on the docket.
Hold on. Let me find them.
Okay.
Okay.
In that case, we were worried that the overriding interest owners had not been provided notice. We are actually just had inadvertently left 2 or 3 pages of our tracking report out of the notice mailing. They were included in our notice report. And so I was wondering if, instead of continuing the cases to June to perfect notice, if I submit the full tracking report with our other revisions today, could those cases be taken under advisement? Or do you think Mr. Fordyce would need time to review them?
I don't know. I think he's still on with us. Mr. Fordyce? There you are.
Yes, Mr. Hearing Examiner, I'm still here.
Mr. Fordyce. Okay, so first of all, Ms. Starnes has some update. Ms. Starnes, which cases are you referring to? Be specific.
They are a 26099, 26100, 26103, and 26104.
Okay, and what did you want to tell Mr. Fordyce?
These were the cases that Mr. Fordyce indicated Colburn and Flotex had not received notice. And I double checked that we just inadvertently left off a few pages of our tracking report, and they did get notice mailed out on the same day as all the other parties, as well as were included in the publication notice. And I was hoping that we could just submit the full tracking report instead of having to continue to June.
Ms. Starnes, if they indeed were noticed and there's no notice issues, and there's just parts of the report that were accidentally left out.
Yes, there should be, I think, 3 or 4
If you
pages
could
instead of
amend
just
those
2.
exhibits, if you could, amend those exhibits and show that my concerns are not necessarily valid, I guess. It was just some paperwork was left out. I would be fine with leaving the record open for that.
Perfect. I can file revised packets with a cover letter indicating which pages have been included and specifically address those parties by name, if that would help. Today, yes,
By 5 o'clock.
by 5
Okay.
o'clock.
So then I will amend now you also know that there were exhibit issues as well.
Yes, and we will update those packets. I think 6 of our 7 packets should be revised by 5 PM today.
Let me make notices. Let me make notes here. So these cases, 26099, 26100, 26103, 26104, we are going to leave the hearing record open until 5 PM today to receive amended exhibit packets.
Yes.
That will not only correct exhibit D2, but will also include the notice information on several pages that were inadvertently left out of the original hearing packet.
Yes, sir. So revise exhibit E, I believe.
Which will address Mr. Fordyce's concern about notice to, I think, 2 parties.
Yes, Colburn and Flotex.
So you're saying they were noticed?
They were noticed, yes, sir.
Very good, very good. Okay, anything else, Ms. Starnes?
That's it. Thank you so
All right,
much.
we're off the record in those cases. I'm now going to call the last case on our docket. This was a notice of violation case that we heard on Tuesday. This is case 26067. It is the Oil Conservation Division versus G&G Oil and Gas Respondent. Entries, please.
Michael Hall here on behalf of OCD and ready to proceed,
Thank you.
but subject to our objections we previously made.
Thank you, Mr. Hall. I remember your objections. Mr. Padilla, are you with us? Mr. Padilla, are you with us? So let me recap what happened on Tuesday. On Tuesday, Mr. Padilla appeared for his client. He filed a motion to dismiss. The motion to dismiss was denied. We then heard from your witnesses. We received your exhibits into evidence at that time. Mr. Padilla asked for the opportunity to bring a witness on behalf of his client to testify. He was given the opportunity to do that. We advised Mr. Padilla that today we would recall the case. He said he would file a motion with an affidavit if he was not available. We've not received any motion with affidavit. Have you received anything, Mr. Hall?
I have not. The hearing was the last time I've communicated with Mr. Padilla regarding this.
Okay, then at this point, the hearing record is closed. The case is taken under advisement. And Mr. Hall, are you going to draft an order?
Yes, if it pleases you, I would be happy to do that.
Thank you. Okay, this case, we're off the record. The docket is concluded for the day. Thank you, everyone.